very good afternoon to you. Lord Janner has been ordered to attend court to face a series of sexual abuse allegations. A magistrate heard detailed medical evidence about the elderly peer's severe dementia, but concluded he is fit to attend. In April, the Director of Public Prosecutions, Alison Saunders, decided Lord Janner was unfit to stand trial because he is suffering from a severe form of Alzheimer's disease. However, in May, 6 of his alleged victims asked an independent barrister to examine her ruling under the right to review scheme. And in June, an independent review overturned the original ruling, meaning criminal proceedings could go ahead. Let's go live to Westminster Magistrates Court in Sky's Tom Parmenter is there. So, Tom, what happens now?
We will hear next week exactly how Lord Janner will appear in court, but it is scheduled to take place back here at Westminster Magistrates on Friday of next week. This was the start of what could be a long legal process to test the allegations that Lord Janner faces that relate to the serious sexual abuse of young people in the 60s, 70s and 80s, 22 allegations in total. And the court process to test those allegations, of course, needs a number of things. It needs to have someone who is a defendant ready to engage in the process. And the acknowledgement from the doctors here in court today was that Lord Janner would not be able to engage in that kind of process. The debate about whether he should even appear at court was the focus of much of today's hearing. And despite the fact that 2 doctors said that in their assessments his severe dementia has deteriorated recently to the extent where he no longer goes into the garden, he spends much of the time in a darkened room watching television. The Chief Magistrate here, Howard Riddle, said that despite those reservations, he wants Lord Janner to appear in court, and now the legal teams are discussing how that will happen, whether it will be a video link or whether it will be a physical appearance where he is brought to the building. The Chief Magistrate acknowledged that Lord Janner's condition means that he will not understand what is going on. He may not understand where he is. He certainly won't be able to take part in proceedings, but the Chief Magistrate determined that Lord Janner should be here. His family, of course, have always denied any wrongdoing on Lord Janner's behalf, and we wait to see next week exactly what will come from that hearing. It is in all likelihood a case that will be eventually referred to the Crown Court and then looked at in more detail by judges.
OK, Tom Parmenter, many thanks indeed.
Let's get more now on the Lord Janner case. We can get some reaction from Paul Mendel QC. He's a criminal defence barrister who recently handled a similar case. So thanks very much indeed for talking to us. We understand from this morning's hearing that the Chief Magistrate has called for Lord Janner himself to be present. Clearly his health has been a matter of debate. Why do you think it's been decided that it's important that he's present at a hearing like this?
Well, it's likely that the very experienced magistrate takes the view that in order to send the case to the Crown Court, it requires Lord Janner to be physically present at the Magistrates Court.
Well, yes, because this is just a hearing, isn't it, ahead of the next stage, and there are different options, aren't there, of what could happen to Lord Janner when facing these allegations of historical sex abuse. What are those options? Remind us of what the next step could be.
Well, the options to get him to the Crown Court, the procedural options are firstly that he attends the Magistrates Court and the papers get sent to the Crown Court. Alternatively, there's a procedure known as a voluntary bill where a High Court judge would sign the indictment and the case would go to the Crown Court in that fashion. Once the case is in the Crown Court, the next procedural step would be for the Crown Court judge to determine whether Lord Janner is fit to be tried. And if he arrives at the view on the basis of medical evidence that Lord Janner is not fit to be tried, then the jury would be sworn to determine whether he committed the acts that are said to underlie the offences.
Well, yes, and explain that, how much scope the jury have in deciding Lord Janner's guilt or otherwise, guilt or innocence or his fate. How much scope do they have in a case where it's just tried on the facts without him present?
Well, they don't decide his guilt, although they can acquit him, so that they can, as it were, decide his innocence, but they don't decide his guilt. They simply decide whether he committed the acts that underlie the offences. Broadly speaking, at the risk of some inaccuracy, every criminal offence consists of 2 components, which is the physical element of the offence, whether it's an assault or a sexual assault or an act of stealing, and then the mental element which accompanies it. When a person is not fit to be tried, the jury do not determine the mental state which accompanies the acts. They simply determine whether the acts were committed by the defendant or not. The trial of the facts proceeds very similarly to an ordinary trial in which the verdicts would be guilty or not guilty. The prosecution present their evidence in the same way. The defence find it very difficult to challenge the evidence because, of course, the defendant is not able to give instructions, and so the evidence, as it were, tends to remain unchallenged, and on the strength of that evidence, the jury then determine whether the defendant did the acts.
And are these sorts of cases, this trial of facts, how common are they?
Well, the Law Commission issued a paper a couple of years ago, and there were some statistics in that which suggested that up until about 5 years ago, the most recent statistics, about 100 cases a year, about 2 a week. So it's unusual, but it's not unique and it's not unheard of.
OK, well, Paul Mendel, very interesting to get your take on it. Thanks very much indeed.